All right, Mr. Saldana, as I told you, I'm a family district court judge.
Correct.
I'm not a prosecutor. I looked at the file. You have filed numerous criminal complaints within the family district court clerk's file. Okay. But those aren't under my jurisdiction.
Are you in a family court here in the state of Texas? If you are, this video is for you. This video, we're going to go over what a district family court judge is. And this will only relate to people that are in a family district court. With that being said, let's dive on in. For myself, I've been in the Harris County family courts for the last 8 years, and I've tried to take a different approach. Every time I walk into a family courtroom, I want to know who everyone is and what their responsibilities to the public are. So I'm going to start off with the judge. Later, we'll do videos on the bailiff, on the court reporter, opposing counsel, and so on. When I grew up, I was told a district court judge has a lot of power, in which they do. And I was told that don't mess with the district court judge because they'll throw your ass in jail. And they will. If you've been keeping up with current events, you have seen where former president, now president-elect Donald Trump, was found guilty of a felony while in office. That being said, that opens up a whole new can of worms. And let's dive into what those can of worms are. So before we get into the judicial duties of a judge, we need to find out where the judicial system came from and what judges are supposed to do. And a lot of people refer to the Constitution, but it actually goes before the Constitution was written. So let's start off with the Federalist Papers. Some of y'all are asking, well, what are the Federalist Papers? Well, that's what I'm going to explain next. The Federalist Papers, paper number 78. If you have a $10 bill in your wallet, it's going to have the face of Alexander Hamilton. Now, Alexander Hamilton was a founding father and a great scholar of government. He was also known for writing 51 of the 85 essays in the Federalist Papers series. They're considered the key part of understanding the United States Constitution. So I want to go over Federalist Paper number 78. And Federalist Paper number 78, authored by Alexander Hamilton, who's on the $10 bill, says this. In this essay, Hamilton explains the role and the importance of the judiciary in the new government under the United States Constitution. Alexander Hamilton emphasized on the necessity for an independent judiciary. He argues that judges should hold their office during good behavior, meaning lifetime appointments, unless they commit a crime or act improperly. Keyword, act improperly, or commit a crime. This independence is crucial for protecting the Constitution and individual rights from legislative encroachments.
In Federalist number 78, Alexander Hamilton explains the role of the judiciary in the American constitutional system. In the essay, Hamilton explains that the characteristics of the judicial branch include appointing judges for life to serve during good behavior, because then they would be more impartial and not pressured by the other political branches.
He also stated the protection of rights. Hamilton also argues that the judiciary may act as guardian of individual rights. The general idea is that judges should maintain good behavior to ensure the independence and impartiality. If they commit a serious crime or engage in unethical conduct, they can be removed from office through a process called impeachment. Now, remember, this is the United States Constitution, but we're going to revisit impeachment in the Texas Constitution as we move further along into this video. Impeachment is addressed in the Constitution, Article 2, Section 4, which states that the president, vice president, and all other civil officers of the United States, including judges, can be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. This process allows the accountability of judges while preserving their independence by protecting them from removal for political reasons. Now, if we go to the Texas Constitution, Article 5, the Judicial Department, Section 1, it's labeled Judicial Power Vested in Courts, Legislative Power Regarding Courts. The judicial power of the state shall be vested in one Supreme Court, in one Court of Criminal Appeals, in Court of Appeals, in District Courts, in County Courts, in Commissioner Courts, in Courts of Justice of the Peace, and in such other courts as may be provided by law. So one of the things I want you to focus on is it doesn't say anything about family district courts. It just says district courts, which means family district court judges do not exist, only in such other courts as may be provided by law. But it's still a district court. It would be the same for county courts, right? And if you look at the very bottom, February 15th, 1876, it was amended August 11th, 1891, November 8th, 1977, and November 4th of 1980. So the Texas Constitution doesn't say anything about a family district court judge. Nothing. Just says district court judge. So if they are a family district court judge, they are still a district court judge. Get it? So scroll a little bit further down to 1A6, and you should see this. Any justice or judge of the courts established by this Constitution or created by the legislator as provided in Section 1, Article 5, which we just read, of this Constitution may, subject to the other provisions hereof, be removed from office for willful or persistent violations of the rules promulgated by the Supreme Court of Texas, incompetence in performing the duties of the office, willful violations of the Code of Judicial Conduct, or willful or persistent conduct that is clearly inconsistent with the proper performance of his duties or cast public discredit upon the judiciary or administration of justice. Any person holding such office may be disciplined or censured in lieu of removal from office as provided by this section. Any person holding an office specified in this subsection may be suspended from office with or without pay by the commission, which is the State Commission on Judicial Conduct, immediately on being indicted of a state or federal grand jury for a felony offense or charged with a misdemeanor involving official misconduct. Remember, the Texas Penal Code has abuse of office and official oppression, and both of those are Class A misdemeanors here in the state of Texas. On filing of a sworn complaint charging a person holding such office with a willful or persistent violation of rules promulgated by the Supreme Court of Texas, incompetence in performing the duties of the office, willful violations of the Code of Judicial Conduct, or willful and persistent conduct that is clearly inconsistent with the proper performance of his duties or cast public discredit on the judiciary or on the administrative of justice, the commission, after giving the person notice and an opportunity to appear and be heard before the commission, may recommend to the Supreme Court the suspension of such person from office. The Supreme Court, after considering the record of such appearance and the recommendation of the commission, may suspend the person from office with or without pay pending final disposition of the charge. A lot of people are under the impression that judges can do no wrong, judges can't break the law, they have the discretion, and they can pretty much do whatever they want. And that's pretty much inconsistent with the Federalist Papers, number 78, and the U.S. and Texas Constitutions. So scroll on down from Article 5 down to Section 7, and it's going to tell you everything you need to know about district courts, judicial districts, district judges, terms or sessions, absence, disability, or disqualification of district judges. This state shall be divided into judicial districts. That's why every one of your court documents has a number in front of district court, because those are the districts. For example, I was in the 257th District Court in Harris County and the 309th, and people are having a lot of problems out of the 280th District Court in Harris County. Again, you don't see anything that says family district courts. It just says district courts. If you scroll down to Section 8, jurisdiction of district courts, doesn't say anything about jurisdiction of family courts. District court jurisdictions consist of exclusive, appellate, and original jurisdiction of all actions, proceedings, and remedies, except in cases where exclusive, appellate, or original jurisdiction may be conferred by this Constitution or other law on some other court, tribunal, or administrative body. District court judges shall have the power to issue writs necessary to enforce their jurisdiction. Again, that was last legislated February 15th, 1976. It was amended August 11th, 1891, November 6th, 1973, and November 5th, 1985. There's nothing in here about family district courts. And if you keep scrolling to section 12, okay, this is the part I want you to really try to understand and comprehend. Judges to be conservators of the peace, indictments, and information. All judges, let me say it again, all judges of the court of this state, by virtue of their office, are conservators of the peace throughout the state. Conservators of the peace, they conserve the peace within the state. An indictment is a written instrument presented to a court by a grand jury charging a person with a commission of an offense. An information is a written instrument presented to a court by an attorney for the state charging a person with the commission of an offense. The practice and procedures relating to the use of indictments and information, including their contents, amendments, sufficiencies, and requisites, are as provided by law. The presentment of an indictment or information to a court invests the court with jurisdiction of the cause. We will be getting into information and indictments later into this video, so please remember that. If you don't take anything from this video, judges to be conservators of the peace. All judges of this court of the state, by virtue of their office, are conservators of the peace throughout the state. Please know that. Let's just go over a little bit of what we've already learned. We've already learned that Federalist Papers set up the structure for the Constitution of the United States, and the constitutions allow us to impeach government officials. Why? Because the Constitution was made to protect the people from the government. So every constitution has the ability to remove any elected government official that is in office, including judges. So now we move to Article 15, impeachment in the Texas Constitution. We were just at Article 5, and remember, the Texas Constitution has all these articles, and in every article you have multiple sections. So let's move down to Section 6, removal of district court judges by the Supreme Court. Any judge of the district courts. Any judge of the district courts. Let me say it again. Any judge of the district court, civil, criminal, family, district court of the state, who is incompetent to discharge the duties of his office, who shall be guilty of partiality or oppression or other official misconduct, or whose habits and conduct are such as to render him unfit to hold such office, or who shall negligently fail to perform his duties as a judge, or who shall fail to execute in a reasonable measure the business in his courts, may be removed by the Supreme Court. So let's go to Chapter 24 of the Texas Government Code. If you go to Texas Government Code Chapter 24, Section 24.603, you're going to see judge. And this is the definition of a family district court judge. A family district court judge qualifications and terms of office are the same as those prescribed by the Constitution and the laws of this state for district judges. A family district court judge is elected in the same manner as a district judge. A family district court judge is entitled to the same compensation and allowances provided by the state and county for other district judges in his county. And that was legislated in 1985, and it went into effect September 1, 1985. Section 24.617 of the Texas Government Code, 309th Judicial District, Harris County. The 309th Judicial District is composed of Harris County, and that was legislated September 1, 1985. So now we know what a district court judge is, right? Now we got to find out what their capabilities are, what they can and can't do. If you were paying attention earlier in the video, you heard that district court judges have the authority to issue writs and any processes in which they can use to enforce the law. If you're in family court, you know that they hold people in contempt. They're able to provide writ of attachments, writ of habeas corpus, writ of garnishments. So these district court judges have that power already through the Texas Constitution. Not just that, but when elected, they have to meet the qualifications of the Texas Constitution and the state laws before they're able to take that bench. So these district court judges utilize the Texas Constitution to get where they are, and sometimes they don't allow litigants to use that same Constitution in which they have used to be in that position of power. Now, let's dig into what their capabilities are, what they can and can't do. So a lot of people have come to me asking about filing criminal charges on judges and how to do it, when to do it, and can you do it? And I've told you in the Texas Constitution, it says they can be removed by the Supreme Court for being charged or indicted for official oppression or misconduct. And this is why I want to make a stop in the Code of Criminal Procedure, Chapter 2, because we're going to go over district court judges who are magistrates and complaints. So let's dive into Chapter 2 of the Code of Criminal Procedure. So when we get into the Code of Criminal Procedure, Chapter 2.05, when a complaint is made, we've talked about indictments, we've talked about information. Now we're going to talk about criminal complaints. When a criminal complaint is made, if the offense be a misdemeanor, the attorney for the state shall forthwith prepare an information based on such complaint and file the same in the court having jurisdiction, provided that in counties having no county attorney, misdemeanor cases may be tried upon the complaint alone without an information provided. However, in counties having one or more criminal district courts, and information must be filed in each misdemeanor case. If the offense be a felony, he shall forthwith and file the complaint with the magistrate of the county. Now, this is very important. 2.05 of the Code of Criminal Procedure is very important because, like we just started, can you file a criminal complaint on a judge? And if it's a misdemeanor, it needs to go somewhere. And if it's a felony, it shall be forthwith and filed the complaint with the magistrate of the county. But what is a magistrate? Who is a magistrate? And who do we file it with? That's the next question, right? So I want you to really try to absorb 2.05. If the offense be a felony, he shall forthwith file the complaint with the magistrate. Forthwith meaning immediately. He shall immediately file the complaint with the magistrate of the county. So let's scroll on down and see what a magistrate of the county is, or who a magistrate of the county really is. If we scroll down to 2.09, who are magistrates? Each of the following officers is a magistrate within the meaning of this code. The justices of the Supreme Court are magistrates. The judges of the Court of Criminal Appeals are magistrates. The judges of the Court of Appeals are magistrates. The judges of the District Court are magistrates. The magistrates appointed by the judges of the district courts in Bexar, Dallas, Tarrant County that gives preference to criminal cases, blah, blah, blah. It goes into here. So if you're in certain district courts, you need to keep reading. But for a lot of us, if your judge is a district court judge, they are magistrates as per the Code of Criminal Procedure. Code of Criminal Procedure is the procedure in which criminal cases are supposed to be adjudicated by, and how and what's the process and how the procedure should go when trying criminal cases. So they're basically saying all district courts are magistrates. Now, remember, when I told you at the beginning, when I was growing up, my dad told me that district court judges have a lot of power. They can do a lot of things, which is true and correct, right? Because they have the powers that were given to them by the constitutions. Now let's go back to 2.05 when a complaint is made. If the offense be a felony, he shall forthwith file the complaint with a magistrate of the county. Now, who did we just say the county magistrates are? District court judges. Does that include family district courts? Absolutely. Why? Because they have district court at the end of them, and there's no such thing as a family district court judge in the Constitution. So constitutionally, all district court judges are magistrates. Supreme Court, Court of Criminal Appeals, Court of Appeals, and district court judges. So what are the things that I've done? I filed my criminal complaint right into my family court case. Why? Because I found out that my district court judge, the 257th District Court and the 309th District Court, those judges are magistrates. And some of the complaints that I filed in there were felony complaints like aggravated perjury and interference with child custody. They're both felonies. One's a third-degree felony. The other's a state jail felony. And where does a felony complaint go? it shall be forthwith before a magistrate of the county as per 2.05, because those are two criminal charges. Also, your family district court judge has exclusive jurisdiction over your court order. It has exclusive jurisdiction over the order in which you might state that your ex violated when she lied on the stand, committing aggravated perjury, which is a third-degree felony, or interfered with your child custody, which is a state jail felony. Now, remember, judges are conservators of the peace, so they shall enforce the law. They have to enforce the law, right? They can't just overlook the law because they say discretion allows them. Discretion doesn't allow a judge to violate the law. And just like Donald Trump was charged, indicted, and found guilty of felony while in office, so what happens when you report your judge's actions to the oversight committee, the state commission on judicial conduct, and they don't do anything, right? That's an issue. Again, they're throwing another barrier or another barricade in front of you to keep you from obtaining justice. So when they throw that barricade up, the state commission on judicial conduct doesn't investigate these judges. So there's no relief for you at all whatsoever. The only relief you have is to file criminal charges, which you're allowed to by way of the Texas Constitution. And just like the Texas Constitution in Article 5, Section 12, it says the same thing as the Texas Code of Criminal Procedure, Chapter 2.10, Duty of Magistrates. It's the duty of every magistrate to preserve the peace within his jurisdiction by the use of all lawful means. Remember, if you're in a Texas Family District Court, they have exclusive jurisdiction of your case. It says it on your court order. They have exclusive jurisdiction. It is the duty, and a duty is an obligation. And what do judges sign? An oath of office to uphold the laws in the Constitution. So everything we've been reading says the judges have to uphold the law. Nothing that we've read so far in this video has said anything about discretion. A lot of people say that discretion allows the judges to make these rulings. Discretion doesn't allow a judge to violate the law, just like discretion doesn't allow Donald Trump to violate the law while he's in office. He was ultimately charged. And again, this doesn't have anything to do with Donald Trump or being political. It just shows that elected officials can be held responsible and criminally charged for their actions while they are in power. So before you can get a charge or an indictment, you have to be able to file a complaint. And that's where a lot of our issues stem from, because the Oversight Commission doesn't investigate their grievances. And the DA won't take charges, law enforcement won't take charges, and then you get to the judge, and the judges don't want to follow the law. So therefore, you have all these barricades barricading you from making your criminal complaints that would help change the trajectory of your family court case. So what I have done is I found unorthodox ways how to file your criminal complaints with your family court judge, district court judge, because they are magistrates. And where did these criminal complaints go? Before a judge who has exclusive jurisdiction over your court order, because it's the duty of every judge, all judges, magistrates, all judges, to preserve the peace within their jurisdiction.
Judge, I would like to say that just earlier, and I hope this is on the record, I asked for a record to be made, that you stated that somebody recording, you have referred that over to the Harris County Harris County Sheriff's Office. But I have made several criminal complaints and you haven't referred any of mine to be investigated. So why are we picking and choosing what we're trying to have investigated?
All right, Mr. Saldana, as I told you, I'm a family district court judge. You know, I'm not a prosecutor. I've looked at the file. You have filed numerous criminal complaints within the family district court clerk's file. Okay, but those aren't under my jurisdiction.
But
those
you can,
that I prosecute.
But you can refer them.
That I refer, and
you can refer them.
You have already referred those matters to the district attorney's office, which is
I have not.
Appropriate.
No,
well, then, sir, I suggest you do so. And we are done. So you are excused. Have a good day.
Thank you, Your Honor.
So we talked about information. We talked about indictments, a complaint. What is a complaint? There's a complaint, an information, and an indictment. For the purposes of this chapter, a complaint is a sworn allegation charging the accused with the commission of an offense. Remember, this is a sworn complaint. There has to be a notary that notarizes this criminal complaint affidavit. It has to be sworn. It's a sworn allegation. And if some of y'all know a little bit about affidavits are statements of fact that people put on a piece of paper in writing and have it notarized and file with some sort of law enforcement agency. But again, if law enforcement won't take it, if the DA won't take it, they tell you to go back to family court. All of these people are going around the law and telling you to just go handle it in a family court. And again, we all know family court judges are not upholding the law. So that's what a complaint is. For the purposes of this chapter, a complaint is a sworn allegation charging the accused with the commission of an offense in the Texas Penal Code. Requisites of a complaint. A complaint is sufficient without its regard to form if it is substantially satisfies the following requisites. It must be in writing. It must commence in the name and by the authority of the state of Texas. It must state that. It has to state in the name and by the authority of the state of Texas. If it doesn't have that, it doesn't meet the requisite. It will not be considered a criminal complaint. It must state in the name. It must state the name of the accused if known, and if not known, give a reasonable description of the accused. It must state the date and time, bear the signature mark of the affiant who's making that criminal complaint, and it must end with the words against the peace and dignity of the state. It must say all of that to be considered a criminal complaint, and it has to be notarized. And if we go to chapter 21.20, information. An information is a written statement filed and presented in behalf of the state by the district or county attorney charging the defendant with an offense which may, by law, be so prosecuted. As a pro se litigant or somebody in family court, you can't present information because it has to be done by the state's district or county attorney charging the defendant. The requisites of an information are pretty much the same as a criminal complaint. It shall commence in the name and the authority of the state of Texas, and it's got to conclude against the peace and dignity of the state, and it must be signed by the district or county attorney officially. So that's the kind of difference between a criminal complaint and an information. But again, if we can't submit that criminal complaint, we can't get an information, we can't get an indictment, which we're going to next. An indictment. An indictment is a written statement of a grand jury accusing a person therein named of some act or admission, which by law is declared to be an offense. And again, you can't get an indictment if you can't get your criminal complaint in. Your criminal complaint shall be forthwith before a magistrate of the county if it is a felony. Now, the indictment, again, that's something we as pro se litigants cannot give. And as per the Texas Constitution, whenever they are charged or indicted, they may be removed from office, but we can't get there without that criminal complaint. Section 39, abuse of official capacity. A public servant commits an offense if, with the intent to obtain a benefit or with intent to harm or defraud another, if he intentionally or knowingly violates a law relating to the public servant's office or employment. Remember, these judges take oaths of office in which they have a duty to uphold the law. So violating the law relating to the public servant's office. Again, discretion doesn't allow a judge to violate the law. It allows them to work within the bounds of the law. And judges are human. They make mistakes, but they don't make 10 mistakes in a row. When they make 10 mistakes in a row, obviously it's to harm or defraud another. And when they send parents to the appeals court to overturn their decisions just basically because they didn't like how you litigated or you presented yourself, that could be abuse of official capacity. But again, you would have to be able to prove these things before you make a criminal complaint on a judge. And again, official oppression, which we talk about in the Texas Constitution. A public servant acting under color of his office or employment commits an offense if intentionally subjects another to mistreatment or to arrest, detention, search, seizure, disposition, assessment, or lien that he knows is unlawful. Let me read that again. Official oppression, a public servant, which is an elected judge, district court judge. They are elected. They are a public servant acting under the color of his office or employment, commits an offense if he intentionally subjects another to mistreatment or to arrest, detention, search, seizure, disposition, assessment, or lien that he knows is unlawful. intentionally denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity, knowing his conduct is unlawful. A public servant, which is a judge, acting under the color of his office. He's in his job description. He is at the bench, or she is at the bench of their employment, commits an offense, intentionally subjects another to mistreatment. Now, again, remember, they are human. They are going to make mistakes. You can't just charge a judge because they made a mistake. If they are calling strikes balls consistently, you have a problem. You need to identify the patterns, and then you're going to have to be able to prove that to make your criminal complaint. So I wanted to know what official misconduct was to the State Commission on Judicial Conduct. So I came to their website and I started looking at some of the grievances or public sanctions that they gave, and stumbled upon this. What is judicial misconduct? And at the very bottom, it says out of court behavior, such as sexual harassment, official oppression, bribery, theft, driving while intoxicated, making threats, or making racist comments. Out of court behavior, such as sexual harassment, official oppression. In court behavior, we've known judges to sexually harass attorneys, and that's where a lot of official oppression comes from, when the judges are acting in their official capacity under the color of law, and they are calling strikes balls. So that's where the official oppression, and we just went over official oppression, and nowhere does it say that official oppression occurs outside of the courtroom. So I think the State Commission, we've known the State Commission to change the words in the Constitution and the laws to favor these judges. So that's why I say the relief that you might seek from the State Commission on Judicial Conduct is not effective. That's why the only relief we have is going through the criminal system and filing criminal complaints on these judges. So can judges be removed from office? Absolutely. The Texas Constitutions and the Federalist Papers talk about how the judiciary is supposed to run, and a judge is supposed to call balls and strikes. Unfortunately, we live in a society now where there's a lot of biases that influences these judges' decisions, and they're not working within the bounds of the law. They're violently wielding their discretion, taking parents away from their children and taking children away from perfectly good parents when they don't enforce the law correctly. It's our job to hold our public elected officials, our public servants, accountable for the position that they ran for. If they are uncomfortable in that position, if they are not competent in that position, they need to voluntarily step down, or they need to be removed from office. Just because they were elected by the people doesn't necessarily mean they should stay and remain in power, as the Federalist Papers have already stated, that they should have lifetime terms when they are able to follow the laws and able to administer justice properly. When they partake in misconduct and abuse of office, they need to be removed. And that's the best part about the Constitution. The reason I say file criminal complaints on judges when they are acting out is because the State Commission on Judicial Conduct for the state of Texas doesn't do its job, doesn't investigate grievances. Should you file grievances? Absolutely. We should have everybody filing grievances. Whether they'll investigate it or not, doesn't matter. We all still need to keep filing grievances on these judges. Now, I can tell you they're not going to investigate it. It is a waste of time, but we should over-inundate this State Commission with these grievances to let them know that they're not doing their job. My past experiences with the SCJC, I filed several judicial grievances and they go absolutely nowhere. It's almost like the State Commission on Judicial Conduct will favor state bar attorneys or lawyers that file grievances, but when it comes to pro se litigants or members from the public, they kind of just look the other way. So in this annual report for 2023, the chair of the commission is District Court Judge Gary Steele. And Gary Steele admonished the public from recording October 2nd, 2024 at the public meeting. I did a video on that. And in that video, the public made it clear that under 551 of the Texas Government Code and the Opens Meeting Act, that we, the public, were absolutely entitled and had the right to record this judicial meeting or this public meeting for the State Commission on Judicial Conduct. So when I say that the State Commission on Judicial Conduct writes stuff, it puts it out, and it sounds really great on paper, but in reality, it doesn't reflect in their actions. The members of the State Commission on Judicial Conduct and commission staff take their obligations to the citizens and judges of Texas seriously. And I can tell you again, they don't investigate. They didn't investigate any of the witnesses that filed affidavits with my grievances. They didn't call any of them, take statements from any of the 12, if I remember correctly, that filed grievances. Texas judicial canons, we've talked a little bit about them. Canon 2A, a judge shall comply with the law and a judge should be faithful to the law and shall maintain professional competence in it. So when you tell a judge that she has just committed a third-degree felony or he has retained the child in violation of a court order, a judge shall maintain professional competence in those laws. When judges don't enforce the laws, they don't maintain competence in it, or they refuse to admonish someone that has violated the law or violated the court order, the trajectory of your family law case goes out. You don't have a fair hearing. And when the Oversight Commission doesn't oversee the judge's behavior in that courtroom, the only relief you have is to file a criminal charge for official oppression. Because again, judges can't use their discretion to violate you. The law is the law. Whether you're the president of the United States, whether you're Joe Blow walking on the street, or you're a district court judge. District court judges are not immune from criminal prosecution.
To attend Harris County Criminal Court at Law, Judge Daryl Jordan was suspended today without pay, just days after his indictment for official oppression. Jordan was indicted on the misdemeanor charge nearly 2 years after he held former ABC 13 investigative reporter Wayne Dolcefino in contempt of court. Dolcefino was sentenced to 3 days in jail for contempt after trying to question the judge while Jordan says court was in session.
And if the SCJC isn't going to oversee the judges and their behavior correctly, we need to lean on the criminal side to uphold our civil judiciary. I hate to bring it to this point, but it's ultimately the lawyers and the judges that have allowed this type of corruption to pervert the scales of justice. With that, I'm going to leave you with this. I hope I was able to bring you a little bit more clarification about removing a judge and how to remove it and filing criminal complaints into your civil case. If y'all have any more questions, y'all know where to find me. And I believe that with times changing, influences, lawfare being used, and judges wielding their discretion, this is the only type of relief we have right now to obtaining some sort of justice within our family judiciary. Thanks for watching, and we'll catch you later.